Good evening.
Good evening, sir.
Yeah, we are happy to have with us Advocate Nitin Meshram, Supreme Court lawyer. And today we are going to talk about this very important happening that's going on in the judiciary. And I think we can use this as a kind of entry point to actually interrogate the Indian judicial system itself. Because all of us have been at the receiving end, and you are a person who is rightly in the middle of the thing, so who else other than you can throw light on this? So maybe you could just briefly introduce this about what's happening in the kind of tiff between the Justice Karnan on the one side and the Supreme Court on the other. So could you just enlighten us?
See, that day I wrote an article in some of the online newspapers, and I took a stand actually. And my stand is that Supreme Court does not have power to, sentence a judge under contempt of court's jurisdiction, and that is under Article 129 of the Constitution. There are many implications of exercise of such power by the Supreme Court. Particularly, first implication is that it takes away the sovereign power of Parliament. The Parliament has, by virtue of Article 124 Clause 4, read with Article 217 of the Constitution, the Parliament has a power to inquire into the conduct of a judge, which is, in the opinion of the Parliament, is misbehavior of a judge, and therefore he can be removed. Here, the Parliament did not initiate any proceedings against Justice Karnan. And Supreme Court has taken the suo motu cognizance of the letter he has written to the Constitutional Office of Prime Minister. He wrote a letter to the Prime Minister's office, because Prime Minister is a de facto head of the country and he has executive powers to inquire into any irregularity, any matter of definite inquiry, any matter of corruption, anything. Means there is no field which can curtail powers of Prime Minister in the matter of inquiry. And we have also an act, the Commission of Inquiry Act. I think it is of 1952. That says under Section 3 that the government will have power to institute an inquiry into the matter of definite complaint or a definite matter of public importance. Now, when Justice Karnan wrote a letter to the Prime Minister should have initiated setting up of a commission of inquiry. That could have, I think, put the things into rest. So far, Prime Minister failed to do that. And I think maybe they would have sent the letters to the Supreme Court for further action, because they usually think that it is a matter of judiciary and it should be resolved through the in-house mechanism. They generally don't try to interfere into the judicial matters or the administration of justice. The Supreme Court thought it otherwise and felt that it is a contempt of the court. Now, first question arises whether the contempt of a court power can be exercised against the judge of a high court who is also a constitutional functionary and who has also a power of contempt of court, because High Court is also a court of record. Supreme Court is also a court of record, and they also have a power of contempt of court. But there are, complications here, because the president is an appointing authority, and the parliament is a removing authority. The judges of the Supreme Court as well as of the High Court are depending upon their continued existence on the parliament. So, whether you are a judge of a High Court or a judge of a Supreme Court, it can only be removed by the parliament. And that process is very difficult to be adopted by the parliament. And therefore, we feel under the Constitution that we have an independent sub-judiciary. Because judge of a Supreme Court or a High Court cannot be so easily at the whims and caprice of parliament. They require a very sound majority of 2/3 member parliamentarians present and voting in the houses, and that too the resolution should be passed in the same session by both the houses of parliament. So look, the situation is, first thing is that the sovereign power of parliament to inquire into the matter of misbehavior, misconduct of a judge, or to remove him is being taken away. Second thing, that the judge's guarantee that he cannot be so easily removed, and therefore without fear and favor he can function. That guarantee, and the guarantee of continued existence, because Constitution has given that guarantee, is being taken away. So here, the judge's protection is being taken away. The judiciary's independence is being tampered with. It is being, it is being compromised with. And therefore, there are many complications in future that High Court judges will be afraid of the Supreme Court judge. Because many of the High Court judges are becoming the Supreme Court judges. It might happen that a judge who became the Supreme Court judge had any rivalry with any judge when he was a High Court judge. So if such High Court judge becomes a Supreme Court judge, then his rival in the High Court will be in a very difficulty. So I think that is a big problem. Second big problem is, take an example that Justice Karnan is retiring in the month of June. Okay, but if he was retiring somewhere in 2020, and if he had some more tenure, more than 6 months of his jail term, more than the jail term, what would have happened? Means he would go to the chair, he is not removed by parliament, and if he comes out of jail, whether still be a High Court judge, whether he still will be a High Court judge. So there are complications.
So basically you are saying that the Supreme Court has kind of overreached its jurisdiction.
It is certainly.
One by in contravention of the constitutional provisions, and also you are saying the Judges Inquiry Act, they have not followed those provisions.
Judges Inquiry Act, you see, Judges Inquiry Act provides for constitution of a committee, and giving an opportunity to a hearing judge, and then a recommendation, the preparation of report, and then laying it before the parliament. And while the parliament discuss it, the concerned judge gets an opportunity to directly address the parliament. So that protection to address directly to the lawmakers is also being taken away. And because there is a enactment under Article 124 by Parliament, that is Judges Inquiry Act 1968, and there are rules of 1969. I feel that the Supreme Court will not have Parliament.
Yeah.
Second important factor is there are judgments of the Supreme Court and it is settled position. That judges means the Supreme Court cannot issue writs to the High Courts. Supreme Court is not a supervisory court and High Courts are not subordinate courts. They are not accountable to each other. Now, by implication of these proceedings, the judges of the High Court will be accountable to the Supreme Court instead of to the Parliament.
So I think you are touching on the very basic tenet of the democracy, that is the independence of the judiciaries, right? And also judicial overreach.
Yes.
I mean, I think judiciary has a very important role to play in the functioning of the democracy, because when there is executive kind of encroaches on these rights of the citizens, the judiciary should play a role. And so also when the legislature tries to go against the constitutional principles, so the judiciary is actually should act as a body which safeguards the rights and the constitutional principles. But in this case now you are saying that the judiciary itself is the Supreme Court at least,
Yeah.
is kind of not acting within that particular frame. Is that?
It is like you see, the Supreme Court is considered to be a protector of the Constitution, upholder of the rule of law, a court which duly complies with the due process of law, upholds the principles of natural justice, and the custodian of Constitution. I don't believe in those, but they are considered to be the independent arbiter between the people and the state. They are bound to comply with the Constitution. Howsoever above, means howsoever you are highly placed, you are not above the Constitution. So, but in this case I feel that the Supreme Court is not going by the dictate of the Constitution. There are certain other factors. Particularly I feel, that because both the authorities, High Court Judge and Supreme Court Judge, and even the Chief Justice of High Court and the Supreme Court, means the of India, they are depending upon their continued existence, depending upon the Parliament for their continued existence. And both of them have been given similar protection by the Constitution. And you see, they have been two pillars of independence of judiciary, and both of them have similar kind of powers of contempt of court, and both of them have a power of judicial review. I personally feel that they are not. They are not vested with the power to inquire into the conduct of each